So welcome back, students. Again, today we are looking for law of agency under the business law. This is an interesting topic under the law under the business law. So we are looking at agency. When we talk of agency, we are talking of two people who come together here to form an agent. So we have an agent and we have the principals. We have an agent and we have the principal. The principal is the one who owns the core activities. The principal is the one who owns the core activities. And the agent is the one who acts on behalf of the principal, is the one who acts or who work on behalf of the principal. That's why the definition here is saying an agent is a person who represent another party known as the principal. So it is such a way to affect the principal legal position. So it will affect the principal legal position because once he does anything wrong, who will be liable? It is the principals, not the agent, not the agent. And then we have the creation of these agency. How do we create these agents? We have the creation of agency. How do we create these agents? So we create it by mutual agreement. You can agree with the principal to perform certain obligation. That's what we call it. It is by mutual agreement. And then we have a ratification. A ratification here is when you do something without authority of the principal. When you do something without authority of the principal, then from there you are creating an agency because the principal will be answerable to your activities, even though he didn't know that you have done that, but he will be answerable to that activities. That we call it the ratification, that is agency by ratification. You can see the definition is saying this is when the agent acts without authority from the principal, but the principal adopt the transaction. The principal adopt the transaction. A good example here is you're working in a company as a petty cash. You work as a petty cash. Who is responsible for the transaction of the company or the management of account of the company? It is the boss or the director of the company. So if you are doing a petty cash and then you end up paying someone for a transport, the boss, they don't have such information or they didn't know, but you have paid that someone. But when you will come later and you inform that I have paid this person a transport, you will agree, and if anything goes wrong, is the one who will be answerable, not the petty cashier. That's how we create the agency by ratification. And then we have the condition. You must satisfy that certain condition. For that, we call it is an agent by ratification. So you must satisfy for certain condition. Number one, agent must have acted for principal. Yes, you must act on behalf of the principal. Number two, they should be a competent principal. They should be a competent principal, not insane, so that you can't say I do it because our principal is incompetent or insane. It is not able to do that. No. So if your principal is in insane situation, then you will not be qualified. That activity will not be qualified to be said it was created by ratification because your principal is not in a good condition. Then we have by the transaction ended by an agent must be capable of ratification. That is the third condition. The fourth condition is that principal must be ratify the transaction within a reasonable time. Yes, so you must inform the principals within a reasonable time. So you must inform the principal within a reasonable time. And then we have the third creation is the agency created by estobel or agency by holding out. Agency by holding out. So what does that mean? It means it arises where a party who has no relationship It arises where a party who has no relationship with the principal represents himself as the agent and the third parties on the representation. It occurs. So if you represent a principal without, you don't have any relationship with the principal, but you end up representing that person, then you will say it is an agency by what? Estoppel. A good example is you find that when there is election, each and every person who is standing for election should have a representative in each and every ward, But you find that there is those interior wards where the candidate will not be able to reach out there and point a representative there. So in such a case, what will the community do? They will just pick any person to represent that candidate for the sake of what? For the sake of elections to be done. Then, so in that scenario, we will say that agency, it was created by what? Holding out. It was created by holding out. And also there must be conditions which they should satisfy these they must be conditioned which they should satisfy this act. Number one, that there is a representation by word or conduct. Yes, there is a representation by word or conduct. There is a representation by word or conduct. Number two, the third party must rely on representation. That is it. And another one is that there is a change in the legal position. There is a change in legal position because the representation became an agent. Yes, that's why I was talking of an election. So it is something that is agent. It needed to be done immediately. And we can't take time to inform the principal that you must have your representative. That's why we will take action immediately. And that is the represented by, it must be something agent. It must be something agent. And then we have another creation by necessity. We have another creation by necessity. So when something is necessary, we create a relationship between our principals and agent. So it's defined and say it arises where a party acts on behalf of the other one without instruction. Yes, without instruction to act in the event of emergency. So we don't need your instruction. So a good example here is so maybe the accident has happened or there is or something wrong happened in the road. So you will find that those breakdowns which are on this side of the road will have to pull out that car from the road so that they can avoid the jam in the road. So we don't need the instruction from the owner of the car to do that because of what? Emergency. Because of the emergency and the necessity of the condition. So you must at least understand the concept of this agency or law of agency. It is a very easiest topic ever. And so once you understand the concept, then it will be very easy to relate. So also there must be conditions which must satisfy these agency by necessity. Number one should be what? Should be a genuine emergency. So you must have a genuine emergency. Another one, say it is impossible for the party to seek instruction from the principal. Yes. So it must be impossible for you to seek instruction before doing that. And then another one, the party must act in good faith. You must act in good faith, or when we say in good faith, it means that you are doing something that will benefit the principal. You are not going against the principal, or the principal will go lost after that action. No. So you must do it in a good faith. And then you find that this necessity now has been classified. So they have been classified we have what is called domestic agency. So domestic agency, we have the commercial. When we say commercial, is something that applies to everyone. It is not for the government. It is a commercial, something that commercial. So say the agent must be in possession of good or of the principal, and emergency arises require immediate action in relation to the goods, and difficult for agent to seek instruction from the principal. Then that's why we say commercial. We have another one which is a domestic also. It's a domestic. Say it arises where the wife has been deserted by the husband and she pledged her husband credit for necessity. For it to arise, the following a condition must be. So number one, the wife must have been deserted by the husband. The wife must be deserted by the husband. What does that mean when we say it deserted? Because we can look at this scenario that husband and wife, there is an agency, the law of agency here. There is the law of agency. There is the law of agency here. So you must have that law of agency to understand, because when you say deserted is something, a place or empty people. So when you say being deserted is that abandoned. So when an husband abandoned the wife can take any action, because who is the head of the family? It is the husband. It is the husband. But if the husband abandoned the wife, or because the word decided is to abandon, the word decided to is abandon. So the wife has to solve the problem. The wife will not wait for husband to come so that they can solve that problem. No, he will solve that problem. And then, so if the wife decided to take that, if the husband decided to take the wife to the court, then the court will answer the husband, say, or the wife will defend herself as that this action, it was what? By what? Domestic necessity. I didn't have to wait for him to come so that we solve this problem. No, it was by necessity. It was very urgent, and a wife will defend herself. That another one is by pledge. The pledging must be what? Genuine. The pledge must be genuine. So those are now the ways of creating this agency, the ways of creating that agency. Then we have the types of agency. We have the types of agency. We have the general agent and the specific agent. We have, remember the agent, we said the agent is the person who works on behalf of the principal. That is the simple definition. That is the simple definition. Now, so what is the general agent? So is an agent engaged to perform several transactions on behalf of the principal in ordinary course of his business. In ordinary course of his business. A good example here is administrator of the company. A good example here is administrator of the company. So administrator of the company will serve several actions, including recruitment, including sales, including the payment, banking, all that. So you see, he's an agent who works on behalf of the shareholders of the company, but he does several transactions. Then now we have a specific agent. A specific agent here is the one who does a particular action. A good example here, we might employ account receivable. So if you employ account receivable, his duties will be specific, maybe raising invoice and requesting for payment. That's why his action has been specified. So that's what we call it a specific agent. We call it a specific agent. Then we have another one. So this specific agent has been classified also into two. We have a progger. We have a progger here. Remember, a progger doesn't own anything. It is just there in the middle of the action. It is just there in the middle of action who negotiate between the seller and the buyer, right? It is the one who negotiates between the seller and the buyer. And then we have another one called factor. So factor is a mercantile agent who is entrusted with the possession and sales of the good with his own name. With his own name. That is called the mercantile action. So these are a good example. We call it like you find that Safaricom is a big company. Safaricom is a big company, and we have several small shops branded themselves as Safaricom shop. Branded themselves as a Safaricom shop. So they are using Safaricom name as a factor. So as a mercantile, so they are using a Safaricom as a mercantile or as an agent. So you find that if you want to register a line for Safaricom, you don't need to go to the Safaricom shop. We have several agents. We have several agents acting on behalf of the Safaricom company, acting on behalf of the Safaricom company. So that one, we call it, it is by the factor. And then we have actionnaire. We have actionnaire. So it's saying it is a mercantile agent licensed by the state to sell a good by the public auction. Yes, that one is a self-explanatory. That one is a self-explanatory. Then now we have authorities in an agent relationship. So which authority does I agent possess? That's what this means. So this agent also must possess certain authority, must possess certain authority, must possess certain authority. So number one is say, agent is supposed to act within his authority. Yes. So you must act within your authority. Number one, we have the real authority, and another one is apparent authority. We have the real authority and apparent authority. So when you say real authority, what does that mean? So it is the authority or the agent has given authority under the contract. Yes, so you must, the principles might define the contract. We have seen the law of contract, and we say the law of contract is an agreement between two parties. So you must have the authority stipulated or stated in that contract. The authority must be stated in that contract. And then another one is apparent authority, which is saying it is the authority which the agent has not been given. Yes, so the agent has not been given authority by the principal, but which he has appeared to have by the conduct of the principal. So you do certain activity, you're doing on behalf of the principal, but this principal has not been given you any authority. But if you execute that action, then the other party will see you as if you have that responsibility, if you have that authority. But it is by apparent, you just adopt it for the assumption of that action or by performing that action. So those are just simple duties. So we will have duties, which is also, it has been tested in most of the exam, duties of an agent. So the first one, we must be do performance, you must perform. Number two is obedience, you must be obedient. Also, you must have duty of care and the skills to perform that action. You must have the duty of care and the skills to perform that action. Also, you must be held accountable. That is why duty to account. You must be held accountable for any action you have done. Also, you must have respect so that you will be doing this thing in good faith, so that you don't make the principle to go loss. So you will do it in benefit of the principle, in benefit of the principle, the benefit of the principle. And then so you find that in any action or in any activities, there must be a conflict. There must be conflict. So not everything will go straight. In one point, there must be a challenge. And what now? So you find that if there is a challenge between the agent and the principal, what will be the action? So the principal has you can sue the principal. You can sue the principals and get your remedies. When we say remedy, we are talking of solution. When we say remedy, we talk of solution. So these are just other explanatory. These are just other explanatory. These are just other explanatory. So you can read those. We have also duties over principals. Say a breach of contract. So these are just self-explanatory. When we talk of a right of lien, is you have right to withhold certain goods for the purpose of maybe you are to honor your obligation. That is the duty of a principal. So you say is a retaining goods of principal as a security until the principals pay you. So maybe this one, you want the principal to pay you the amount you have agreed. So you will not give him or her those things you hold until that principals complete his obligation of payment or any other one. And then there's another main thing we need to look at this topic is the termination of agents. How do we terminate this law of agents? How do we terminate this law of agents. Number one is by mutual agreement. If you agree with the principal that I will be no longer providing you this service, so I want to terminate it. So you can agree it by the word of mouth or by writing. And then another one is by death. If the principals or agent die, then that agency will automatically come into end. Another one is performance. So if you underperform that action, then the principals might decide to terminate that contract. Okay. And then another one by lapse of time. Maybe you agreed, I will perform this thing for 3 months. And then once that 3 months has elapsed, then we will terminate that contract. And then we have another one by bankrupt. If the principal is no longer able to pay you, then you can decide to terminate the contract. We also have the frustration of the contract. Maybe this person is not sticking to the terms and condition of the contract. There is a frustration. So what do? You quit. What do? You quit. So that topic makes the end of this topic. That is the topic of agents. So it is a very simple topic that you must understand who is the principal and who is the agent. So you must understand the duties of an agent and the duties of a principal. Also, you must understand the remedies of a principals and an agent in case there is a conflict. So let's meet on the next topic, which we'll say next topic again. So thank you, and keep on revising, asking questions, leaving comments there, whichever you meet these lessons.